Hello, ladies and gentlemen, and welcome to yet another edition of Focus on Liberia. This is FOL Justice Forum. My name is Dennis Jai, and we are broadcasting from Atlanta, Georgia. In tonight's edition of FOL Justice Forum, we're going to be looking at part two of the Supreme Court of Liberia. And there are a lot of writs in the country that are in the courts, right? Including the one that I know, writs of habeas corpus. But tonight we're going to be looking at the types of writs that the Supreme Court entertains. Again, the discussants are Councillor Frederick A.B. Jewell, who is joining us from Denver, Colorado. Councillor Jewell, welcome to Focus on Liberia.
Thank you very much, Dennis. I'm happy to be here.
We are expecting Councillor Jerome Verdier, who is going to also be joining us, and Attorney Mariah Yakula, who is also going to be joining us. And Councillor Jewell, we started last week with the Supreme Court and we discussed the structure and the functions. Just for those who are joining us for the first time, give us a brief summary, maybe for 2 minutes, the summary on the structure and the functions of the Supreme Court, if you don't mind, sir.
So the Supreme Court of Liberia is the highest court constitutionally in the Republic of Liberia. The Supreme Court receives all appeals from the lower court, the specialized courts, on matters that have been decided by them. The Supreme Court also structurally is made up of a Chief Justice and 4 associate justices. So if you were to just look at the bench, you'll find out that the associate justice to the immediate right of the Chief Justice will be considered the most senior associate justice. The next will be, and the Chief Justice in the middle of the, so there will be 2 justices on the left-hand side and 2 justices on the right-hand side, the Chief Justice in the center of the justices. The next will be the first will be the most junior, until the last justice, who may be someone who just joined, like Mr. Justice, my good friend, Mr. Justice Kabar, Yusuf D. Kabar. He is the last associate justice that joined the bench. Functionally, the Supreme Court the Chief Justice will always appoint one of the associate justices to be in chambers, meaning that associate justice will receive all of the rates that we are going to discuss today. And so decision made by the Supreme Court is final. You don't appeal from the Supreme Court decision as compared to the lower court. So guarding our democracy, guarding the rule of law, the Supreme Court is very important in all of the processes that go on in Liberia.
Ladies and gentlemen, that was the voice of Councillor Frederick A.B. Jewell. Councillor Jewell, thank you so much for that summary. Again, this is FOL Justice Forum. This is where we discuss the legal issues in the country and the impact of our legal system or the justice system on the people, the citizens, their human rights, their fundamental rights, and their livelihood as a people. We've recognized that the justice system is a big part of us, and if it goes wrong, everything in the country goes wrong, because then there is no hope. We learn from our civics that the government is 3 equal branches: the legislative, the executive, and the judicial. So the legal system or the justice system, that's part of our judiciary. And so if the judiciary is strong, a lot of things can go right. So we think that this is a very important topic to discuss. So let's jump right into it. Today we're going to be discussing rates. So the different rates. Let's start with, what is a rate? What is it used for? And what is the purpose of rate in our court system?
So a rate, or the rates that are issued, and I'm saying the rates that are issued depending upon what is issued by the Supreme Court or issued by the specialized or specialized circuit courts. They carry a command. A rate is a command from the court to an individual to act certain way. In other words, to appear in court, if it is a civil matter, to appear in court within a period of 10 days and defend yourself. Now, in several cases, rate of summons are very important because, or the rates in general are very important because without the issuance of a rate by the Supreme Court or any of the circuit court or the specialized courts, the court that may want to take jurisdiction over a particular matter will have no right to be able to hear a complaint filed against that person unless a rate is issued. It is a rate that brings them under the jurisdiction of the court to be able to say, at the end of the day, enter a judgment either for the plaintiff or for the defendant. In the criminal case, it's a rate of arrest. If a rate of arrest is not issued, even though there might be an indictment before the circuit court is an indictment, there could be an indictment. If the rate of arrest is not served on the defendant or defendants, the court has no authority or no jurisdiction over the people. One interesting thing that occurred in the issue of rate, at a certain time, I represented Miss Ellen Cochran. There was a case that the government Liberia brought economic sabotage complaint, indicted her and so forth. But the government of Liberia could not bring Ellen Cochran under its jurisdiction because criminal COSI could not arrest Ellen Cochran and have her brought under the jurisdiction of COSI because at the time Ellen Cochran lived in the United States and the government couldn't serve the rate at all. So once a rate is not served, the rate is as powerful and as important as when it's served on the person named in the rate. So it's an order of court, but the order of court must be served. There must be a return, meaning the court officer must say that he or she saw Councilor Frederick Jewell and served him with a rate of summons. And Councilor Jewell or the clerk at my office received the rate and signed for it. In a rate of summons situation, if I'm named, then I must be served personally. You can't leave it with my husband. You can't leave it with my wife. You can't leave it with my son. You must find me and you must handle me a copy of the rate. So the rate in the system is very important because it gives the court the authority to make decisions against the defendant.
Thank you. Quite recently, we've been hearing the name of some rates, especially in the ongoing trial involving the CPP or the ANC political leader. How do you call that one again? Rate of something publica.
Near Essex Republica.
Right, near Essex Republica. So I mean, what are rates? Are those Latin names? And so tell me a little bit about that near Essex.
Those are Latin names, but near Essex Republica saying you can't go anywhere. You will stop you from leaving this country in simple terms. So it is an interesting rate. Near Essex Republica cannot be issued unless there is a formal action pending before a court. So you cannot jump on one day and say, Jewell can leave Liberia and we go issue near Essex Republica. No, you must either issue an indictment pending against Jewell along with a writ of arrest, or there is an ejectment proceeding pending against Councilor Jewell. And so if Councilor Jewell should leave, it will be impossible for the court to enforce its judgment. So then near Essex Republica will be issued to prevent me from leaving. And it's one of the rates that are issued, they're restricted to the lower court. It's never issued by the Supreme Court.
Thank you. And we're going to get into that. I mean, I heard the name and I wanted to bring it up. Another rate, the name I heard, I think it was during the trial of Grady Allison, habeas corpus.
Yes,
there was no more days I heard this. What is that?
It is one of the powerful rates that can be issued by any of the circuit courts of Liberia, any of the lower court other than the Supreme Court. This rate is restricted to any of the circuit court. Magistrate cannot issue it. So a judge in criminal court A can issue that rate, in B can issue it, C can issue it, D can issue it, E can issue it. A judge in a civil law court can issue that rate. What that rate does is that it commands the government of Liberia to produce the living body of someone who is allegedly detained by the government of Liberia. Most of the time, that rate will be issued to be served on NSA because they are the ones that are very notorious in arresting people secretly and keeping them. in most cases that will happen, or it will be a rate issue against the Ministry of Justice and the police to bring to court the living. You hear the living body, meaning that because people can ask a question: should they bring the dead body or what? No, the rate is saying that you have this person, you must produce him in court. So there exists writ of habeas corpus, and there exists a compulsory writ of habeas corpus. So what that means, when writ of habeas corpus is issued, let's say issue and serve on the Director of Police and the Minister of Justice to produce the living body of John Joseph. And the writ was served. The court officer came back and reported to the court that we serve the Minister of Justice, we serve the Director of Police and all his deputies. And then the day to appear for the hearing of that writ was not honored. The government did not produce a living body of Joseph John. And then the person who filed the writ, it is a writ that says that the liberty of a human being, of a person, is restrained unlawfully.
Right.
And therefore, a writ of habeas corpus is issued to be able to bring the person from wherever he is detained. In the daytime, the army police will take people to post and go keep them there. So you hear writ of habeas corpus is issued to be served on the Minister of Defense and on the Chief of Staff, everybody else that are in top position in the military. So it is a rate. The importance of that rate is the habeas corpus is that it is a rate that its issuance can never be suspended. The Constitution provides that habeas corpus must always remain alive and active to be issued, and is restricted to the circuit court. It's not with the Supreme Court. It is, and in most cases, the government will bring the person, or if they don't produce a person, then if I'm lawyer representing John Joseph, and the government did not produce him, or NSA did not produce him, for example, I will go back to court and file a motion for the issue of the writ of compulsory habeas corpus, meaning that the officials that are named in the writ in the second time can be arrested. That we can arrest them and bring them to court.
Thank you.
Hi, my name is Addie Tyler from Pennsylvania, and you're watching Focus on Liberia.
Welcome to Focus on Liberia, and this is Supreme Court Part 2. We're going to be discussing the writs that are issued by the Supreme Court. Only the Supreme Court has the power to issue those writs, and that's what we're going to go into. And I turn it over to Councillor Jewell to tell me about the different writs that the Supreme Court can issue or the Supreme Court entertains.
So there are 5 writs named in the civil procedure law, and they are listed under section 16.21, 1, 2, 3, 4 in the civil procedure law. Now, why am I saying civil procedure law? So there exists a criminal procedure law that deal with criminal matters, only criminal matters. And there exists a civil procedure law that deal with civil matters. It does not lay down how criminals are treated or how criminal cases are treated. Civil procedure law lists them as: the first is a writ of certiorari. Writ of certiorari, I will name all of them and then I will address them. Would that be okay?
Yeah.
So a writ of certiorari, that's the first writ. The second is a writ of mandamus. Some people say mandamus. Some people say mandamus. It's also a Latin word. Then a writ of prohibition. Then a writ of error. That's the fourth writ. And the fifth writ is a writ of Co-Warranto. Writ of certiorari, writ of mandamus, writ of prohibition, writ of error, and writ of Co-Warranto. These are writ restricted only to the Supreme Court of Liberia.
All right, let me see if I can remember them. We have the writ of certiorari.
Yes.
We have the writ of mandamus, the writ of prohibition, the writ of error, and my favorite, the writ of Co-Warranto.
Yeah.
I like the name. I don't know what it means, but we'll go into it.
I'll explain it. And these writs are issued by the Supreme Court under a process called special proceeding.
Okay.
And I'll explain why it's called special proceeding. I'll explain that. But let me treat the rate first. Rate of certiorari is a rate it's a rate that is issued during a special proceeding. It's a rate that is issued by the filing of a petition before a justice in chambers. Let me go back. None of these rates bring the case directly before the full bench of the Supreme Court when they are issued.
Okay.
Meaning that it must start with the justice in chambers.
Okay.
And then must walk its way back to the full bench of the Supreme Court.
So are they issued directly or they are issued through a lower court?
No, the lower court has nothing to do with any one of them.
Okay.
They are restricted completely to the Supreme Court. So when we're discussing the structure of the Supreme Court, we said there are 4 associate justices and 1 chief justice. The chief justice is the administrative head of the Supreme Court. Whether the court is in section or out of section, whether they're on vacation or they are not on vacation, the chief justice will appoint one person who will always be considered as a justice in chambers. It is before this person that the 5 rates that are named must originate. In other words, a petition for a rate of certiorari must be filed before a justice presiding in chambers. Why are they called presiding in chambers? It means that the justice, this is not the full court hearing the case. It's one person designated periodically by the chief justice to be able to receive these petitions. So there's a petition for certiorari. A petition for certiorari is filed when a means suit is pending before the lower court. This rate is an instruction to the judge and the lawyers hearing a case before, let's say, civil law court. Let's say before the debt court. Let's say before the probate court. Let's say before the tax court. These are all lower court. They are subordinate. They are considered subordinate courts as to the Supreme Court. Supreme Court is the higher court of the land. The rest of the courts are the subordinate court, but they have general trial jurisdiction. So in the case of there is, and it happened, the rate of certiorari can also be issued in criminal cases. So right now, a very good example is that there is a case before court C. This guy, Calono, George Calono, went to the government of Liberia and complained that $390,000 was stolen from his account from one of the banks in Liberia called, I think, GT Bank. And so the government saw the probability, of course, decided that there is evidence here, will issue a writ of arrest for the bank officials and the bank itself. Now, the bank is considered as a person in law because corporation. The individual that work for the bank, they are also considered a person, but they are the official of the bank. So the writ of arrest and the indictment brought the bank officials to court. And so the bank is in court as a defendant, and the officials of the bank are also in court as defendants. So recently, the lawyers representing the bank filed a motion for severance, meaning that try them separately. The bank said, the officials say, look, the bank is a corporation in law considered as a person. The bank operates as a person. So we don't want to be tried along with the bank. So we want to be separate. Let's proceed trial separately. So the judge, His Honor Siafakeri, entertained the argument and agree with the officials of the bank and say, we'll try the bank separately and we'll try the officials separately. The government of Liberia said, we don't see any reason why you're trying to separate them. So we went to the Supreme Court to complain. Their complaint came as a petition for a writ of certiorari to review the interlocutory or the intermediate judgment of Court C. So you see how certiorari is being used. There is a case, the main case remained downstairs, still before Court C. But the intermediate judgment or the interlocutory judgment or the judgment that the judge made, which is not the final judgment, it is that judgment that is being reviewed by the justice in chambers. So if the justice in chambers review that judgment by way of writ of certiorari to review the judgment, so there has to be a case downstairs and there must be a certiorari proceeding taken for that case. If the justice in chambers should agree with the government lawyers and rule and issue the writ of certiorari, first, what is filed is a petition. The fact that the petition is filed doesn't mean that the justice will issue the writ. The justice, in most cases, will issue a citation citing the government lawyers and the lawyer for the bank to a conference. At the conference, the justice will say, oh, okay, well, I think there's reason to issue this writ. At that level, when the writ is issued, the justice will come after they have heard. Once the writ is issued, it brings the parties under the jurisdiction of the Supreme Court. A citation will not, because it is a writ that gave the court the authority to decide who is wrong and who is right. And so if the justice in chambers should agree with the government lawyers, then the lawyer for the bank can appeal now to the full bench of the Supreme Court, meaning all the four associate justices, the three associate justices, and the chief justice that did not participate in the case will be allowed now to hear the case clearly as to whether or not the justice ruling was correct. So that's how certiorari works. It's view a judgment that is not a final judgment, but it's a judgment made during the trial of the case, which a party considered to be injurious to him or to her. So he runs to the Supreme Court.
So now the Supreme Court goes ahead and issue that writ of certiorari. What does it do?
What it does is that it says the Supreme Court, for legal terms, the Supreme Court has put a stay, S-T-A-Y, on the entire proceeding in the court below, meaning the Supreme Court has stopped everything, because the writ will instruct the judge and the lawyers to stop everything and appear before the justice in chambers on certain date. And if the writ is issued and sustained, because the writ is issued doesn't mean that it will be sustained, meaning that the judge could hear the petition and the other side and say, well, the writ doesn't make sense. It doesn't make sense. The petition doesn't make sense. I think the judge is correct, so I will dismiss the writ. But if the justice in chambers sustains the writ, then it means the judgment is entered. Take the government case, for example, the judgment will be in favor of the government lawyers or the Republic of Liberia. And if the defendant lawyer disagree with the justice in chamber, they will appeal to the full bench of the Supreme Court. That's how the matter gets to the full bench when a certiorari is issued. But it's a writ. What I'm interested in is that it is a writ that is issued to review a judgment of the lower court. It can be criminal matter or it can be civil matter.
Thank you. Let's go to our next writ.
The writ of mandamus. I like this one because it's also restricted to the Supreme Court. No lower court can issue a writ of mandamus, meaning none of the criminal court can issue a writ of mandamus. The civil law court cannot issue a writ of mandamus. The debt code, labor code, and all the other special law codes below the Supreme Court cannot issue mandamus. Mandamus is restricted to the Supreme Court. It is a writ that compels people to do their duty. So I think you brought one time where you brought up that you've written a book and the Constitution in there, and the government should have distributed the Constitution or have it taught in the schools.
Right.
And nothing happening. Now, the question is, can you sue as an individual who basically have interest in the Constitution being taught? The answer is yes. So then you will be going to file a petition of mandamus for the writ of mandamus, served on the government of Liberia, represented by the Ministry of Justice, and all officials of the government of Liberia, to come to court and explain to the justice in chamber why has the Constitution, as mandated in the Constitution itself, has not been taught. Why? And you will be asking the court to force the government to put money aside to teach the Constitution in all of, maybe you say high schools, all of the junior high schools, maybe elementary might be a little bit too young to go through that, but all of the junior high schools and all of the schools in Liberia. And then you will also name the Minister of Education as a respondent, because he's responsible for education activity. Let him come to court representing the government to come and say why is the Constitution not being taught. So mandamus is also a special proceeding, but it commands and obligates a government official or anybody in corporate position to perform the duty that they are required to perform, that the law requires them to perform. So
Right.
it forces people, it compels people.
And I like the example you gave about the Constitution, so it makes it very clear for me. And thank you for that. An extraordinary rate commanding an official to perform a ministerial act that the law recognizes has an absolute duty and not a matter for official discretion.
Correct.
And that's so. Who issues that petition to the Supreme Court? How does it get there?
So any Liberian who think that he has an interest in the teaching of the Constitution, and that he also has an interest in ensuring that the Republic of Liberia obeys the Constitution as stated, which includes having this become part of the social services class, or social studies class rather, for high school students, junior high students, and perhaps college students. So you who feel that the Constitution should be taught and have seen the need to write on it, and have books, you got book around that people can buy, could go to court and hire a private lawyer to compel the government. So let me answer your question another way. Any non-government official can file it.
Wow. So let me prepare my, and to that, Lawrence Power is asking this question. Can he sue the government of Liberia while the Constitution has not been taught in our high school? So I think that's what you were explaining.
Oh, yeah.
Lawrence is asking that question.
Yeah. So the mandamus cannot be brought by the government of Liberia. It's normally brought by civil society actors or people like you who have written a book on the Constitution and decide that, I think it's important that our schools, high schools, junior high schools, learn part of their social studies. They become not just geography and something else, but it become known become taught along with other social service courses.
Right.
Social studies
this is
courses.
the book.
Yeah.
It's called The Republic of Liberia, Foundational Words of Our Nation. Article 10. The Republic shall ensure the publication and dissemination of this Constitution throughout the Republic and the teaching of its principles and provisions in all institutions of learning in Liberia.
Okay. You know what? If I'm a lawyer for you, what I would do, we'll send a copy of that. We'll write the Minister of Education rather, and send a copy to him and say, we demand that you teach, you do what the Constitution said. Right here in a nice letter. And say, we demand that my client demand that you do what the Constitution said, because you're responsible, you're the overall supervisor of education in Liberia. We're giving you next school year when school open, within the first 30 days for you to begin to instruct all of the schools to start teaching it. Or we'll sue.
Yeah. And what will issue now will be the writ of mandamus.
Yeah, so there'll be a petition for the issue of a writ of mandamus.
Oh, yeah, a petition for the issue of a writ of mandamus. Let's go to our next writ by the Supreme Court.
So yeah, that's the second writ. The third writ is a writ of prohibition. Prohibition is a writ that is also powerful. It says that something wrong is happening, and so the Supreme Court must order a stay, order that it stop. And if the wrong, the thing that you consider wrong has been done, this writ will undo it. It will return the party to status quo ante, return them to where they were before, as if the action. Let's take for example, you have a 30 acres of land in Sando County. Let me be practical. And then a logging company decide to say we're building our headquarters here, and you then go to the county attorney and say, look, I think they land belong to me. I don't think that a logging company should go ahead and begin to build on it. So I want, I think this is criminal trespass. I want a conference to be held between the company and me. And the government library continue to drag its feet to the point that you see the company building its headquarters, about 10, 15, 20 houses on the land. And you decide to file a formal lawsuit before the civil law court, maybe to eject them from there. And in that process, you think that prohibition to stop the entire thing could be a rate to be issued, or that an administrative decision has been made against you, and you think that decision injurious to your interest, and so you're asking for prohibition or it's about to be entered, and you're asking the Supreme Court to issue a rate of prohibition, which is a powerful and harsh rate, I would call it, to stop the wrong that you think has been done against you, or to undo the wrong that has been done against you. It also will come by way of a petition, which is referred to by our law as a special proceeding. This rate is also restricted to the Supreme Court. It can't be issued by any of the lower court. None of the special high court, none of the circuit court can issue the rate. It's also a rate that is restricted to the Supreme Court. And
Thank you.
When an issue is either stopped, the parties start again. If you wanted to go back to an important thing, you want to go back to the case of what you call them when you want to go back to the Brandon Samaka case. He was about to be certificated. The government Liberia fled to the Supreme Court, filed a petition for a rate of prohibition to stop the Election Commission from certificating him, and that rate traveled onto the full bench of the Supreme Court. And today, Brandon Samaka is considered as a legally disabled person, and so he cannot proceed further. So that's what the rate of prohibition will do.
Thank you. We've been joined by Councillor Jerome Verdier. Councillor Verdier, welcome to FOL Justice Forum. How are you today?
Thank you, ma'am. Fine. I'm very sorry that I'm late, but I think Councillor Jiwe for leading the fort. He's a leading scholar and practitioner on constitutional law and Supreme Court practice. While I was absent, I followed the discussion. I think he has done more than justice to it. But I just have a little
Councillor, welcome.
question to throw to Councillor, since we are discussing rates. Thank you, Councillor. I wanted to ask, the way we have started talking about these intermediate courts, will we be requesting that they have those remedial powers also to issue those rates? Do you think it's practicable?
Let me tell you an interesting thing.
And before you come in, I don't understand the question. It's too legal for me.
I think the background is not given. That's why you don't understand it.
So give me and our listener the background.
So
Councillor Jerome, where are you coming from?
Okay, I think Councillor Verdier can say that.
No, Councillor, proceed and answer, give the background. Or
So if you follow our chat room, I think about a week or two ago, we were discussing that Liberia has grown. We now have 15 counties.
Yeah.
So when Liberia just had four associate justices and one chief justice, Liberia at the time had 9 counties. So now that we have 15 counties, almost all of the cases from all of these counties are going to the Supreme Court on appeal.
Right.
The Supreme Court does not have the capacity to hear all the appeals, so injustice is being done. So I suggested, and I also contacted Councillor Verdier and Janet, that we think it's important that we establish an intermediate appellate court, meaning that like the Supreme Court, like the U.S. Supreme Court, cases don't travel to the U.S. Supreme Court on appeal. It's by way of writ of certiorari, by leave of court. But the appellate courts, which are below the Supreme Court of the United States, I was thinking that we could have a statutory provision for the establishment of intermediate appellate courts in Liberia, leaving all appeal to go to those courts. So let's say we have Mangibi, Bong, Lofa, Nima, Grand Jira to be one judicial district. So five high court judges, or how you want to call them, could sit in Banga, for example, and become an intermediate court. It could happen in Buchanan too. So one court could sit there, another could sit in Maryland or something like that. But it was a discussion we're saying, and so Council's question is that if these courts are statutorily set up, should the writ of mandamus, should the writ of certiorari, the writ of mandamus, the writ of prohibition, the writ of error, and the writ of co-warranto be issued by them?
Okay.
The answer will be yes. What do you call it? Policy-wise, what we're looking for is to take away the enormous work on the shoulders of the Supreme Court and leave people to go to the Supreme Court where constitutional issues are raised. You know, for example, a political party will say, you know, I am being stabbed by the Election Commission. It is my constitutional right to be able to contest positions, elected position in Liberia. That's a constitutional issue right there. So that matter should be the lawyer representing the party should be able to petition the Supreme Court, not the intermediate appellate court, should be able to petition the Supreme Court to hear him or hear them. All other appeals from Lofa, from Grand Jida, from Nima, from Mangibi should be heard by the intermediate appellate court sitting in Banga.
Okay. Before we continue, I'm hearing this word now. I'm thinking appellate court coming from the word appeal. Mm-hmm. So what is an appellate court? What does it?
So it is for appeals, as you rightly said.
Okay.
Right now, as it is, all appeals from the specialized courts, the circuit courts, they all go on to the Supreme Court. And guess what happened? The Supreme Court is not able to hear more than 25 cases per year or per term. So maybe the whole year the Supreme Court, if they work hard, they will hear about 50 cases. How many cases on the docket of the Supreme Court that have been there before I went to law school? Many. How many people have died and the cases have not been heard? Many. Is the Supreme Court capacitated to hear all the appeals? No. It's a speedy process if you have intermediate appellate court sitting in Banga, sitting in Bomi, sitting in Grand Bazaar. I just name in this country. I basically don't know what they will say there. But basically, by policy, I'm saying, you know, the 5 judges sitting in Bomi County to hear cases from Cape Man, Bapulu, Bomi County, what other county near that. So bundle them into group so that the appeals are heard by those courts in those regions.
Yeah.
Instead of coming onto the Supreme Court and they get locked up, they never heard, and people die. Or people's right, and do away with the justice. I think the justice in Chima situation for me is like violating the rights of people.
Yeah,
because when one justice says we can't hear the case, so what? Then that's it, right?
Yeah, thank you. Mm-hmm. And Councillor Berdia, welcome. Already we discussed the rate of certiorari, the rate of mandamus, and the rate of prohibition. If you have anything to add to any of those, else we move to the next rate.
No, let's go on.
I didn't hear you, sir.
I see what I had as a concern was what I raised for Councillor Jewett to address. You know, so we can move forward because that's the next direction our judiciary is going.
Thank you. Our next rate here is the rate of error.
Mm-hmm. And I think you were asking why is it error?
No.
It's error because it's actually error, which is funny. This rate gave the party, it also restricted the Supreme Court. But this rate, interestingly, is the only rate that will go before the full bench of the Supreme Court. So mind you, certiorari start with the justice in chambers. Rate of mandamus must start with the justice in chambers. Rate of prohibition must start with the justice in chambers. Rate of error does not start with the justice in chamber. It goes directly to the full bench of the Supreme Court. All four associate justices and one chief justice will have to hear the petition that is contained in this rate. It's restricted to the Supreme Court. But again, it is a rate that goes directly before the four associate justices and one chief justice. What does it mean? What does it do? Councilor, you want to add?
Oh no, go ahead. I thought you were finished.
No. What does it mean and what does it do? A rate of error is a rate that comes as a result of a petition. So a defendant in a civil case, let's say there is an action of ejectment at a civil law court, and the case went on throughout the process until the day the judge said, okay, next week Monday or May 1, if it is a working day, we enter a judgment for this case. But then he said pending assignment, or doesn't even give a date, he said pending assignment. So instead of assignment, on May 1, the judge go ahead and decide to hand down his judgment or her judgment, because it could be a lady. And the other party, which is a defendant, does not know that the case is assigned for hearing on May 1 because the judge said this case will be heard on May 1, but pending assignment, meaning that it could be May 1 or it could not be May 1. When the judge said this case will be, the judgment in this case will be decided, I will be handed down pending assignment. Forget what they did. And the other party did not have the time to come to court, because if they came to court and the judgment was against them, the lawyer representing that party, those party or parties, would stand up on his feet and he would say to the court, at this stage, counsel takes exception to the judgment of your honor and announces an appeal to the Supreme Court of Liberia. You must announce appeal to a judgment that you disagree with in order to appeal it. But these people did not have the situation that I just named for you. They did not have the occasion because they were not in court. They did not know that the judge was going to make a judgment. In spite of that, the judge entered a judgment in order that the defendant should be evicted from the 25 acres of land near the EAW junction, for example. Or they see on Saturday morning 2 to 3 bulldozers coming in, that they're coming to evict the people from the place. So the lawyer who represents the defendant would then run to the Supreme Court, file a petition for a writ of error, and the court would be asking the court to stop all proceedings because he or she was not given the opportunity to be able to appeal. This writ brings the entire matter before the Supreme Court, so that the right that the defendant had to appeal, but were not able to appeal it because he or she did not know the case was assigned, and that there was no notice of assignment. So there's a mistake actually made in the case. Maybe the judge would be thinking that he ordered the assignment to be served on the defendant, and that the defendant was served. Maybe an assignment was issued in the case for the judgment, but when the court officer went to the lawyer office, the lawyer had traveled out of the country, and he's the only lawyer of record in the case. And then the judge said, well, the lawyer gone out of the country, we are going to enter judgment. So then the writ of error would be used to correct the error that the lower court is said to have been made. 2 things. One is that this writ starts by a petition. 2, this writ goes directly to the Chief Justice and all of the 4 associate justices. It's different from the other 3 writs I just talked about, because it goes directly to the full bench. You are muted.
What is considered as an error? And it's a rate of error coram nobis, a variation of the rate of error, and provides a court the means to correct its own error. So why would the lawyer think this is an error?
Well, one good factual example is that let's say the judge actually said on record when the plaintiff and the defendant were in court that the judgment in this case will be heard pending assignment. So that is not a date. It just said the judgment will be heard pending assignment. There will be a date slated and will serve a notice of assignment on the defendant and the plaintiff. But the judge forgot that he did not order the clerk to issue a notice of assignment to bring the parties to court. And then the other lawyer show up in court on, let's say May 1, show up in court on May 1. He said, Your Honor, we are here for your judgment. The judge, instead of reviewing the record to make sure that a notice of assignment was issued and the parties were served, the judge went ahead and entered a judgment, ordered the people evicted, and then the lawyer for the plaintiff got a writ of repossession or possession to be served on the defendant. And the next thing, Saturday morning, you find bulldozer driving to the place to evict the people. So was there a mistake by the judge by not issuing the assignment? Yes. Because he thought that he issued it. Or the other thing is that the assignment was issued, but on the back of the notice of assignment, the court officer must write and say that he or she saw Councilor Jewell, who is a lawyer in the case, and saw Councilor Vaudier as a plaintiff lawyer and served them. But maybe he wrote on the back of the writ and said, I only served Councilor Vaudier, but I was told that Councilor Jewell is going for a case in Kakata. So Councilor Jewell was not served. And the other thing is that I had to be the only lawyer of record in that case. So it's not an excuse that I'm going to Kakata. If other lawyers are associating with me in the same case, then any of them could be served. And the other thing is that when that happens, if I'm the only lawyer in the case, then an error has been committed.
Thank you.
Or somebody could just tell the judge, Your Honor, I don't think Jewell want to come to court. Let's go hear this case. It happens. Lawyer can do that. Some lawyers can.
Councilor Vaudier, is this common? Is there any example you know of where this?
There are many examples, but I want to say a little bit that Councilor didn't emphasize. In Liberia, the right to appeal is an undeniable right. Everybody have the right to appeal. No matter how clear the case is, if you say you want to appeal to the Supreme Court, the judge must grant you that. So the law assumes that it is a mistake or an error when somebody didn't have the right to appeal the final judgment, so the court can review what the judge did. So you see all the circumstances that Councilor explained, it means in the end that you are not, maybe your lawyer didn't represent you well, or your lawyer didn't have the assignment representing you, and something happened to him, and a judge didn't take note that your lawyer was not in court. He went ahead to make a decision. And to avoid this error, I don't know what, I'm sure Councilor have had that experience. And when I'm in court, and in cases like that, I have asked the judge to get another lawyer to take the appeal for the other party that is missing.
Oh, yeah.
So that party can not come later on. You know, I wasn't present, and so the judge was wrong because I didn't have the right to appeal. There have been cases more than 3, 4 times, 5 times. The judges were very cautious. They said, no, we get somebody to take this ruling and announce an appeal on behalf of the absent lawyer. Because if you proceed with the case and there's no right to appeal, there's no opportunity to appeal, you deprive that person of their right. So how do you repay it? That's error. And as Councilor said, because of the right of appeal is involved, all 5 of the justices have to consider it, not one person. And your lawyer may have been negligent, or your lawyer forgot to take an appeal. It has happened before. I've had a case. It went against the other party. He forgot to take an appeal.
Wow.
So when the judge was concluding, I called the attention to the judge. I said, I think he should have the right to take it. This is right. I announced it. I said, but he didn't. If you listen to him, he didn't take appeal. He just said accept, and he will take exception and exercise his rights under the law.
Wow.
I see, and that only right that is available to him now is for him to take an appeal, and he failed because the final judgment.
And taking an appeal, meaning I'm not satisfied with this case, I'm going to the Supreme Court?
Mhm.
Exactly. I will do something about it. But now just see, and then the law has a period within which you can do all your research, review what you have done, and decide whether or not you still want to proceed with the appeal. But it will be available to you. You have enough time to prepare yourself for that. So it's a very, very important, and I like it. And I like most of the Supreme Court rulings on error. Counselor, most of them also penalize the lawyers in those cases.
Mm-hmm.
Because sometimes not a judge deliberate effort was negligent. He failed to announce an appeal. He failed to follow the appeal process.
Mm-hmm.
And the court says, well, the appeal process is jurisdictional, right?
Mm-hmm.
Before your case goes to the Supreme Court, you have to follow all those processes. And when you fail to follow one, then you deny your client. The rate of error comes in to give the client relief to ensure that the client has all his rights protected.
Thank you.
As previously we said,
Mm-hmm.
our laws are good, but the enforcement of the law. And one issue I will give on how good our law is. In criminal proceedings, our law doesn't allow a defendant to plead guilty. If you go to court and ask you, how do you plead? Say, Your Honor, I'm guilty. I committed a crime. The judge will not allow that. Even though you say you're guilty, you plead guilty, the judge will enter a non-guilty plea on the records so that the other party can prove that indeed you are guilty. That's how interesting our law is. Sometimes it's slow, but there are some very good and strong aspects of the law.
Thank you. That takes us to the next one.
Co-Warranto.
Which is
The rate of Co-Warranto. I mean, as Councilor said, is appeal is a constitutional right. And if what I have witnessed, I mean, to add, is that I have witnessed that the judge has appointed attorneys at law who may have little experience, and he or she will say, counsel accept to the ruling, as Councilor Vodia said, counsel accept to the ruling and give notice to court that he will take advantage of the law as may and provided. That's not an appeal. When that happens, the rate of error will come into play.
And who will file it in that case? The same person who said?
No. Maybe what the court does is that appoint somebody who is an attorney at law or counsel at law that is within the court area. Maybe I just enter, say, oh, law court, I went to go talk to the clerk, and the judge said to me, Councilor Jewel, you are hereby appointed to take the ruling for Councilor Vodia. This case was signed, and the record says that Vodia received the assignment, but he is not in court. So even though you're not part of the case, but you are legally under an obligation to take the ruling for Councilor Vodia. And then I will sit there. You can't say no, you sit there. I will sit there after the judgment. I, as a lawyer, should know that after a final judgment, I must announce appeal, and Councilor Vodia can pick up the appeal process from there. But I must say, counsel accept to this judgment and hereby announces appeal to the Supreme Court of the Republic of Liberia. I must say those words in open court. I can't say I would take advantage of the statute. In most cases, the lawyers who do that are inexperienced attorney at law, people who just graduated from law school and maybe started to practice and don't, really don't understand. Or some of the older lawyers who have not practiced at all went to go work as a legal counsel for one corporation and doesn't know what the practice look like and doesn't know what it should be like. So then there's an error right there. But I can let's move on. Then Co-Warranto is also a rate that is specifically restricted to the Supreme Court.
Councillor,
Councillor Brody, are you saying something?
I just wanted to add something before. I know if we come back, we forget.
Okay.
It's on the same appeal process, and why what you say is very important. You announce, you keep in my mind, you say you have to announce the appeal to open court because it gives notice to the other party and all other persons involved in the case. The case is announced as an appeal to the Supreme Court. Nobody's supposed to do anything in the case. Like the example Councillor Jira was giving, let's say the judge had decided you'll go and move them from there. You'll take the bulldozer and go and break everything. If that happens and the appeal is announced, it brings a full stop to everything until the case goes upstairs and the Supreme Court decides. That is very, very important. I thought as soon as he spoke of the announcement, taking an appeal, I thought to emphasize that it's important because he gave notice to the judge, to the court officers, and the other party. And it means full stop to this case. Don't do anything again on this case until we hear from the Supreme Court.
Yes.
Thank you.
So the next rate is a rate of Co-Warranto. Again, this rate is limited or restricted to the Supreme Court. Co-Warranto does not go directly to the full bench. It starts with a justice in chambers. It is a rate that asks the question, by what authority are you acting? Or you say you're the president of the Republic of Liberia, the election results say that you lost, Councillor Jewa won. But then you go in one corner and decide to call your own people, swear yourself in. It happened in Kenya when the Kenyan, I forgot the guy's name, but he been in opposition a very long time. When he lost, what's his name?
Raila.
Yeah, Raila Odinga.
The two family there. Either Moa or Odinga. So
Odinga went somewhere by himself in some hall, and had the people to swear him in as president. So, and then the president who the election commission announced that won was also sworn in as president. And so the question was, if you wanted to know how was Raila Odinga functioning, by what authority you had to function as a president of Kenya, when in fact the election commission, which is the official agency in Kenya of government that's also announced election result, has announced that the other guy won, the current president won. So Co-Warranto can actually ask questions. Or that the other thing that could happen, let's take it back to Liberia. And I see that happening a lot. The president could name Councillor Vodia as Minister of Justice. But without going through the confirmation process, or what the confirmation process is on, Councillor Vodia begin to function effectively as Minister of Justice. Close down Firestone main office for failure to be able to pay government taxes. Shut down LAC in Buchanan for non-paying taxes for the 5 years. Begin to act immediately as Minister of Justice. Writing opinion for the advising the president that this election must be postponed because I think it meets the legal guideline. I am the Minister of Justice. I am the Attorney General. I can advise you. The Attorney General is responsible to advise the president on all legal matters. So the question is, by what authority, Co-Warranto, if you wanted to stop Councillor Vodia from doing that, you could file a petition for Co-Warranto asking Councillor Vodia, why are you acting for the Minister of Justice when you have not gone through confirmation? Or that you were dismissed. Let's say Councillor Jewa were in the Labor, you were Minister of Labor, and he was dismissed. But he continued to call Firestone people to meetings, call Lamco to meeting, all the other company and things, and begin to conduct government business as if you're never dismissed. So the lawyer for Firestone could proceed and find out that the president is not doing anything about it, even though the president know that he had dismissed me. But he's doing nothing, and I go to work every morning and begin to act on behalf of the government, collecting taxes and all of that. Maybe it's okay that I'm collecting taxes on Firestone for the government, even though I'm dismissed. So then Co-Warranto will say, by what authority do you have to act as the Minister of Labor? Mind you were dismissed last week Friday for administrative reason. The president dismissed you. So where are you coming from asking the LAC people to come and hold a meeting at the Labor Ministry? Where are you coming from trying to stop the people from conducting their strike? You know more, Minister, man, get out of here. That's what the rate does. The rate asks you, why are you functioning in a position that you have no authority to function in?
Thank you. Today is Easter, and I remember Matthew 21:23. Jesus entered the temple courts, and while he was teaching, the chief priests and the elders of the people came to him. By what authority are you doing these things? They asked, and who gave you that authority? So these people were issuing Co-Warranto.
Yeah, but they must go to court. They might think about Co-Warranto. They could have been thinking about, because the thing is, Co-Warranto does not become a proceeding unless a petition is filed before the Supreme Court. They just in chambers. And so you can't just say, I want to file a writ of mandamus for the government refusing to teach the Constitution to your house. Right. Or you give a speech somewhere, you say the government must teach the Constitution. It's not doing that. So we think mandamus is an appropriate proceeding. Yeah, you may be correct, but you're not in court. You're outside the courtroom. You must seek the authority of the court to be able to enforce that. So I know, Mr. Your co-host, Anthony C. were asking, and I didn't want to confuse you. I were asking, what are the rates that the lower court should issue? I thought that should be left for another day so that we can be able to go deeper in it. Because if you just basically throw it in right now, it will be confusing people. So we just talk about the rate that belongs to the Supreme Court. Why is he talking about the rate in the lower court? I think we should set a different day.
No, definitely. Let me have Councillor Verdier chime in if he has anything on the rate of Co-Warranto, because those guys and those chief priests, they were not to the Supreme Court.
And in fact, I wanted to throw in a question so Councillor Jiwe can elaborate on it. Whether Co-Warranto will apply to private citizens or organizations. Say for example, University of Liberia Student Union have an election, and then there's confusion afterwards for one of the parties that feel they want to go on and store themselves and move in the student union office. So they are acting as the leaders of the students. So to avoid conflicts, students fighting and rioting and all of that, can one of them do it, or can an officer, an authority in government go to the court on behalf of the state to preserve the peace? And I said, Co-Warranto is a good rate that resolves a lot of, especially election issues, and most of our examples are elections related, or if people's mandates have expired and the president have not renewed their mandate, and while they were waiting for the president mandate to be renewed, they go ahead issuing authorities, and then maybe the president doesn't renew their mandate.
That is, thank you for that. That's very important. It happens here. Bond County Association, when they went to election, they had two, one group met in Minnesota, another group met in Philadelphia, and they have two presidents. So really, can I go to the Supreme Court and put a Co-Warranto on one of them that I don't like? or one of them that I think is illegitimate. So,
So-
let's use this. Let's use the student LU student also example. Since it's
So,
not
so the rate of sanctuary is not limited to asking government officials.
Co-Warranto.
Yeah, it's not. It's not limited to just government officials or people who are acting, outside of the mandate through confirmation or whatnot. So, if the university, let's say the two parties, one they call what, ASAP, one of them they call ASAP.
Soup and something else.
Yeah, Isa and Soup.
ASAP and SWAT. Those are the two popular parties on the campus. And
Isa the old one, Studa the recent one.
Oh, okay, yeah. So yeah, ASAP, let's say the old one, decided that SWOOP did not win. They do not need the government intervention to hire a private lawyer to file a petition for Co-Warranto. So let's say the SWOOP people said they won, and they begin to structure themselves. This person responds, just how everything else can be, happening in the student movement. So you can request the Supreme Court. So what the Supreme Court would do, it will review the election process and everything that went into it and determine whether SWOOP is the winner or not. So again, it's not a rate that just only asks government officials. Let's say there is the National Port Authority or RIA, for example, or a corporation, a private corporation. The board of director names. He went ahead and named rather Joseph Jackson as based upon the shareholder decision. Joseph Jackson is appointed as a president. But the shareholder said, no, we in our when we met, we chose Joseph Jackson. We chose Jacob Norris. How come the board of directors is not honoring what we said? Because my shareholders are principally the owners of the company because they got share in the company. They bought share. They don't run the day-to-day activity of the company, but they are owners of the company in that the share that they bought and they vote, they go to shareholder meeting and vote. And if the person who is now appointed as president by the board is appointed outside of the shareholder meeting, a petition for Co-Warranto can be issued, and the writ can be served to ask that president to come to court and establish, by what means is he functioning.
Right, and let me give another example. We have a situation in the Liberty Party right now that recognizes Musa Belete as the chairman, and then but before that, we had the Yomli Kanga faction have their own party chairman, and then we have two. So can Musa Belete faction or the Yomli faction go and file a Co-Warranto at the Supreme Court and say should it be a prohibition to say stop functioning as the chair or a Co-Warranto? Can they do that?
So it was to go for prohibition, you will have to establish the illegality of the entire process.
Okay.
And it must be hatch. It must be to undo the illegal act. If I would choose Co-Warranto, because it would say that the Nyomli faction is impersonating us, the Liberty Party. Or Nyomli faction could say that we had a meeting in Grand Bassa County. I think that's what they did. We had a meeting and we elected Steve Zago as the chairman of the Liberty Party, and we expelled Musa Belete. That's what they did. All of these things are facts. And so Musa Belete has no right to be filing a lawsuit along with ANC at the Election Commission. But what I've been hearing the lawyers saying, which is strange to me, is that Musa Belete lawyers say they will go to the government librarian and ask them to arrest Nyobi Kanka and the rest of the people for impersonation, and which is a criminal thing. You got to be very mindful, because in criminal matter, the government of Liberia maintain exclusive responsibility to prosecute or not to prosecute. So I will not go behind government lawyer to say, y'all come and arrest people. Because the same people that arrested people, they could turn around and say, we don't see evidence in the case and will not prosecute. So if you went by Co-Warranto, the Supreme Court reviewed the record and say, wait, did Nyombi Kanga and her group meeting in Grand Bassa County meet the constitution of the Liberty Party? Is that a way you can expel your chairman? Or is Musa ability with the authority to suspend Nyombi Kanga and the rest of them? So Co-Warranto will review who actually has the authority to head as a chairperson. I will not play around with arresting because I never trust the government to go follow behind any case that I'm going to file. So why am I going to ask some government lawyer to? And in some cases, those lawyers who think like that, they can go to the government and ask for what they call letter of patent. The government of Liberia will give you an authority to go say, okay, you can prosecute the case on behalf of us. Our inner case, where the government issued a letter of patent, and the government went to court without we knowing and had a judgment. Even though we're the lead counsel in that case, when we went to the Supreme Court said, you Councillor Jewell and Councillor Stowfield, may so rest in peace, you don't have an authority in criminal matter. The government gave you the authority, the government takes it back. And so we lost. So you will go back Co-Warranto to be able to question who actually is the chairman. The other thing is that it makes it faster because the Supreme Court will hand down a final judgment and say, Ability, you are the chairman, or Steve Zago, you are the chairman. So all the playing around, going to government lawyer, arrest this person, it makes no sense to me.
Councillor Brodia, you were laughing.
Yes, I try to avoid working with the prosecution. That's why I don't do a lot of prosecution cases. Because our government lawyers, I swear, they are difficult to depend on. And then again, as Councillor explaining, I'm wondering, in the midst of all this confusion, why no party has taken advantage of. As he said, would have just brought a conclusion, a termination of the conflict.
Correct.
Instead of all the wrangling that is going on, but we are not politicians or lawyers for them. So that's why I was laughing at how people choose different approaches to the law.
Right.
And another thing that struck me, the reason why arrest people and put them in jail, not that they want justice, but they want to prove that they got power or they got authority over you.
Right.
And from the Liberian experience, by the time they put you in jail, then they forget what the case was.
That's it. You are in jail for good.
That person will just be in jail and be there, language in jail. Sometimes you go to the court. I mean, the prison got people there who there for 6 months, 7 months, just for petty offenses.
5 years. 5
Yeah.
years. 5 years. 10 years.
5 years. It's true. I mean, that's why I didn't want to say, but it's true. People just sitting on there. You just carry people to jail. They put them in jail. And normally they will use the weekends.
Yeah.
They grab you on Friday. They put you inside court clothes on Saturday, Sunday. Then Monday, everybody forget about you. If you don't have contact, you don't have money, then you just suffer in jail. That's all they do.
Ladies and gentlemen, if you are just joining us, this is FOL Justice Forum. We are discussing the Supreme Court of Liberia. This is part 2 in the series. Today, we are looking at the types of rates being issued by the Supreme Court. We'll take a short break. When we come back, we're going to read your comments.
At Focus on Liberia, we discuss everything Liberia, from education to politics, arts and culture, entertainment, agriculture, history, religion, family, and technology. Focus on Liberia uncovers and showcases the best of Liberia and shows the world the truth about Liberia. We educate, elevate, and promote all things Liberia. We conduct interviews, panel discussions, debates, and more. Tune in to Focus on Liberia on Facebook and YouTube and be a part of the stories that make up the news.
This is Focus on Liberia, and I am Dennis Jah.
Welcome back to Focus on Liberia. This is where we educate, we elevate, and promote all things Liberia. We have a few comments here that we want to read here. Judy Wahumu, I think you need to train the current jurors you have first in order to be qualified for their respective position. Thereafter, you can move to the next stage. I understand that some of your lawyers are now well-schooled and are not practically fit to adjudicate certain tedious cases. Counselor, talk to me about the Liberian Code. I think we have very good lawyers. We've been having good lawyers.
People who say that, I would say in most cases, do not know how the court is run. Do not know why lawyer proceeded the way he or she proceeded. We conclude that all lawyers are corrupt. All judges are corrupt. All lawyers, the Louis Otto Grand School of Law, I heard somebody saying one time that the woman Ephraim Smallwood, then they're no longer alive. So the Louis Otto Grand School of Law is not good anymore. Going to the law school is the first step to be able to learn the technicality of the procedure and whatnot. It depends upon when you get out what you wish to do with the degree that you have. It doesn't mean they are not educated. They are educated, but there are people who will say, okay, I want to be a lawyer and go work as a legal counsel and sit down in one corner, and advise National Port Authority and carry home $10,000 every month as the legal counsel for LPRC or National Port Authority. Those people, you don't rely upon them to come to court and defend your interest because they don't know anything about the trial proceeding. It doesn't mean they are not lawyers. They are lawyers. But they are limiting themselves to, being out of court, so they don't really understand a lot of things in the courtroom. It doesn't mean they are not educated. They just basically consider themselves corporate lawyers, or they consider themselves working for the big companies, and that's what they would do. They would not come to court. I have no way to believe that, people who go to the law school, they are not educated. Some of the people have different degrees before they went to the law school. The law is just added as something to their education. So a lot of them are educated. I would say that do not leave your case in the hands of a brand new lawyer, somebody who just graduated from law school, or somebody who just managed to take the Supreme Court bar exam and pass, and it's called counselor at law. And so you give your case to him, thinking that the guy can start the case from the magistrate court to the circuit court to the Supreme Court. That could be true, but he or she may not. The question I normally ask most people is that how many jury trials have you been in? Explain to me. One time I called Liberia, I wanted a lawyer to associate with me, and the lawyer is a very good friend of mine. In the political side, he's a very good human rights advocate guy. And I call not told, so this person should not say told. And I was told, I asked the lawyer, I have an ejectment suit that we wish to file. You know what the lawyer told me? He said, we can file it in criminal code C. Oh my goodness. Criminal code C is a criminal code. So why are you telling me? So I just closed the conversation with him. I never worked with him anymore because I knew he did not know the differences of the code and where to go. We got some of them like that. It doesn't mean they are not educated, but they are not practiced enough to have sufficient experience to be able to go. Another case was a guy, instead of action of death, he went and filed, instead of a labor action, it's an old lawyer. Instead of labor action, this lawyer went to the debt court and filed an action to recover, I think, almost $50,000 or $150,000 from LPRC. And the defense lawyer filed a motion to dismiss for lack of jurisdiction. And the motion was granted.
Thank you. Councilor Varia, if you can put your body up a little bit, you can adjust your...
I was hearing echo and I thought it was coming from me. I wanted to...
Okay, good. You're good now. So we're going to read more comments, but if you want to call to join the conversation, the number is on the screen. Please call that. We have Glenda Jane say hello. We have Bia Wei watching us from Australia. Welcome and thank you for watching. Eric Sire is joining us from Barclayville in Grand Croix County. Thank you so much. William Bigie is watching from Fishtown, River G. Thank you so much. Lawrence Power is watching us from Clarksville, Tennessee. Thank you, Lawrence, for watching. Milfield Deco said, Dennis, you have my support to sue the government of Liberia so as to compel the Ministry of Education to teach the Constitution in all schools. Thank you, Derek. I'm going to be in Monrovia in June, and I'm going to file that petition for the writ of mandamus. I know that. I would say Councilor Jewett told me. Yafa Biakpe, wow, the facts has explained related to the Colando case is misrepresented. I don't know. You got this information.
You tell me where you got this information, thank you.
Zeus Carter, a writ of prohibition is a writ directing a subordinate to stop doing something the law prohibits. The writ is often issued by a superior court to the lower court, directing it not to proceed with case which does not fall under its jurisdiction. Okay. And so on and so forth. Councilor Jewett, isn't the Supreme Court process or procedure take much longer time as compared to, say, going to the lower courts?
Oh, no. Do you want me to answer?
Yes, please.
Well, no, it depends upon what you're talking about. As we mentioned, the Liberty Party complaint situation is a very good example. If you were to start, if you had a lawyer who is not experienced, he will go file a petition for injunction before the civil law court, along with a mean suit. What that does is that it prolongs the process. You may get to the end of the rope, you may get a judgment, the case will travel to the Supreme Court on appeal. But why do that when you could go on a writ of Co-Warranto, a petition before the Supreme Court directly? Why would you want to go by injunction when you could go to the Supreme Court directly? Again, as I said, because the court is overworked, because there are a lot of cases in the court, it doesn't mean that the court is not doing some good work. It's doing some good work, it's just overworked. I think too many cases there.
Thank you. Lawrence also said, are 2 appellate courts enough? I don't think you said 2, you said 3, right?
I said 3, yeah.
So are they enough?
I think 3 will be enough. You have 15 judges, 5 in each of the courts. And they be responsible for appeals instead of the Supreme Court.
This one from Flomo Livingstone. I'm in class to learn about my Constitution because I didn't learn it in school. Welcome to class, Flomo.
Very interesting, Liberia.
For this one from Fishtown, Dave Jason, hope you are doing well in Fishtown. Tim Gonglo, through his Maryland representative, Abraham Toh, will be visiting River G shortly. Dave, we're talking about the Supreme Court here. You are running.
Is it Tim Gonglo? Well, maybe he's a public relations officer.
Maybe he wants to
say.
Yeah, so those are some of the comments so far that we have, and we have no one calling yet. I think we should wrap it up.
Okay.
We should wrap it up. Okay, this one from Ishmael Dukley. Does the NEC has authority over the CPP LP versus the UP ALP case? Does the NEC have that authority, or somebody will issue a co-warrantor?
Well, the LEC, not LEC, the NEC responsible to regulate all election matters. The question is the case before the the NEC properly constituted, meaning that does ANC and Liberty Party Ability Wing have the authority, have the standing to sue on behalf of CPP. I mean, it was interesting. That's one of the issues the defendant then raised for their judgment during trial.
All right, we still have a few comments here. This one is from Rambeli Yanle. I would suggest that this rate, I think is referring to the Co-Warranto, be used against the Monrovia City Mayor Jefferson Tamakoji. He's operating unconstitutionally. I think we have to explain this rate a little more. It says Koji is operating unconstitutionally. How, Mr. Rambeli Yanle?
Was he fired? Was he dismissed?
Yeah, if he's dismissed and still working, then Co-Warranto will ask by what authority? Who gave you the power you're using?
Maybe he's an exercising authority that doesn't belong to him.
Okay, so please, Rambeli, let us know what is he doing unconstitutionally, or which power he's exercising that does not belong to him, so that the lawyers can weigh in on that. This one from Ameke Sali. What do you need, or what's stopping us from establishing appellate courts to ease the logjam at the Supreme Court?
People have not thought on the policy. Or interesting. It was one of the things the WIA government discussed early when it went to Farmington River. There had some meeting there, I think in the very first 6 or 7 months when WIA came to power. And they were discussing it, but I don't know what else happened. I think the Bar Association and lawyers that have interest should go ahead and write a statute and maybe submit it to either ask the Senate. You can start with the House of Representatives, the Senate to be able to pass into law the establishment of intermediate appellate courts in Liberia and the appointment of judges.
Thank you. Fokpa Kado said this program is very informative. Thank you, Fokpa, for watching. And again, our phone lines are open. The number is in the ticker there. If you have not done so already, please call the number on your screen, 605-313-6004. The code is 791403#. At this time, we want to announce that tomorrow at 5 p.m. Eastern Time, 9 p.m. Liberian Time, we're going to be on the radio in Liberia. That's FM 105.5. We're going to be sitting down with the Bombay County Association, and we're going to talk about the history and geography and the economic climate in Bombay County first, before we even come to the history of the organization, their current state, their plans, what being their challenges, and their prospects. The president, the current national president, Musa V. Willie, the founding member and first national president, Reverend Boama Edwards, and the Secretary General, El Vani Lemi, will be my guest tomorrow, right here on Focus on Liberia. Councillor Veria, Councillor Jewel, we need to conclude. Today, we talk about the rates and the different rates that the Supreme Court can issue. Let's wrap up with your closing comments, and let me start with Councillor Veria.
Well, thank you again for another opportunity, and I want to commend my colleague, Councillor Jewel, for sitting tight and being the process. One matter I'd just like to raise, I'm sure Councillor Jewel will say something about it in his closing too, that most of these rates to the Supreme Court require that you file a bond. And most of the time is an indemnity bond. Because if the matter is in court and you go to the Supreme Court by any of the rates, most of the time it puts a stop to the process that was going on. And if in the end, some lawyer or some party just filed those papers for frivolous and serious reasons just to delay or to frustrate the other party, And then the Supreme Court takes its time, go and review the case and realize that you shouldn't have brought this case in the first place. The bond will stand to indemnify the other party if they were experienced damages because of the delay or the frustration of their process. The bond can get them. Most of the time, lawyers don't bother with that. The process requires bond, and the Supreme Court, almost all the time, except in extreme cases, will insist that before they hear your case, you file that bond. And your indemnity bond will be saying, look, I'm a good lawyer. I represent as a case that you Supreme Court must hear. We're not doing it to delay or to grant justice. We're doing it because we believe that we have a cause that the Supreme Court must intervene in. This is a good process, and that's what you didn't say, but we have started discussing that we should find a way to see how we can put forward a recommendation for the establishment of those intermediate agreements. It requires lawyers putting in their time to do research, and I'm trying to suggest to Councilor G where they get our colleagues. In advance of all of that, we can begin to have 2 meetings on those issues to see if we can lay the foundation to see the major issues. And the other thing also, I hear.
Councilor Brody, your audio, you are not really audible now. You are kind of low and going in and out.
Yeah, I wanted to raise has to do with the Constitution, not teaching the Constitution. That's an issue I think we can take up also.
Thank you.
Yeah, thank you.
Thank you. Councilor Joel?
Yeah, again, I would just add that these discussions are very important for our people, the Liberian people and residents of Liberia, even foreign national business people who want to go to Liberia and do business there. It's very important to know the preliminary of what the laws in Liberia will be holding or hold to. And so it's important that we pay attention to them because it helps to educate our people. It helps to clarify our minds. When you hear the rate of Co-Warranto, what is it? What is the rate all about? If you hear the lawyer, government lawyer, or the private lawyer have filed a petition for a rate of statutory, what is that? Going through the rates are important because, and why are the rates, restricted to the Supreme Court and not with the lower court? So if you hire somebody, for example, and that lawyer told you, I have a situation where there's a land issue before that one lawyer, some people from my state hired the lawyer. And the lawyer knew that the parties have deeds. The defendant had a deed, the plaintiff has a deed. The lawyer told these people, took 6,000 naira from them and said, I can file a summary proceeding to recover possession of real property at the magistrate court in Calcutta. That's untrue. That's untrue. Because these are involved, so the matter must be filed before the circuit court in Calcutta, not before the magistrate court. So when you learn all of this, you quickly tell the lawyer, no, I'm not going to pay my money to you because our on the show I learned that since I have deed and other people have deed, we need to go to the circuit court and not to the magistrate court. So why pay somebody money that they will not do anything that is legal? Or either they did not know, or they knew and decided to take the people money. And that was the situation. So this proceeding will be helpful to our people to be able to understand all of the, not to make you a lawyer, but it gives you real good information that you can be able to make some decision for yourself.
Thank you. Always here at Focus on Liberia. I just want to acquaint you with our programming. On Tuesday, we have the Hour of Politics, Tuesday 1 p.m. Wednesday 1 p.m., that's Eastern Time, we have Roundtable Africa. Wednesday 10 p.m., At night, that's Eastern time, we have sex and relationship conversation. Thursday, 7 p.m., Tough Talking Thursday. Friday, 6 p.m. Eastern, the literary hour. Saturday, 3 p.m., we have FOL Marketplace. That's our business, economic, and finance forum. Saturday at 7 p.m., we have the Labrador History channel where we do Labrador history. And Sunday, 10 a.m., oh, no, it's 1 p.m., 1 p.m. Eastern, we have the New Day. That's a show on the issues of confronting women and girls. Sunday, 2 p.m., we have the Labrador Dream. And Sunday, 4 p.m. is On Point. Always here at Focus on Labrador, we have diversity of programming that we do. We're not a one-way traffic. So keep it here every week, every weekday, and even the weekend. Focus on Labrador. We educate, we elevate, and promote all things Liberia. Councillors, I want to thank you so much for your time. We want to also thank our viewers for always following us here at Focus on Liberia. At this time, we're going to close the broadcast with our song that says, "We are all Liberians." Whether you believe a co-warranto should be issued on the city mayor Koji or not, we are all Liberians, and we must do whatever it takes to make Liberia the glorious land of liberty. Have a good night, and God bless you.
We are Liberians. Liberia is our home.